Good evening, everyone, and welcome to today's audio webinar on real estate legal strategies and compliance. And thank you so much for joining. My name is Ravi Polishetty, and I will be the moderator for today. I would like to, welcome Chris. And Chris is a partner at PSBP Law. And Chris brings the deep expertise in the real estate law, including entity structuring, capital raising, and partnership protection. Chris, truly thank you for your time today, and over to you.
Great, thanks, Robbie. Good to see everybody. I'm going to share my screen here. Let's see here for some slides. All right. Little delay here. Can you guys see that? No.
We can see, but is there any way you can maximize?
Let's see here. It's showing the wrong screen. Let me see if I can switch to a different screen. Should be the full screen.
Yep, we can see now.
Okay, perfect. All right, well, welcome everyone. I'm going to try to give a general overview of some of these topics. There'll be time at the end for any questions. There's a lot of detailed information, so I kind of skimming over some of it to the best as I can in an hour. But again, just introduce myself. Let's see here. Why are we not? There we go. All right. Okay. Again, I'm Chris Barsness. I'm a partner with PSBP, formerly Patel Law Group. We are based in Irving, Texas. I practiced the first 20 years of my career in California, moved out here to Dallas about 5 years ago. And I work on primarily business finance type of matters, but my specialty is securities. So that's setting up investment funds, real estate syndications, mergers and acquisitions when people are buying and selling businesses. All right. So a couple of things we're going to talk about today is basically some of the entity structuring for real estate, capital raising and securities compliance, partnership agreements, exits, pitfalls, and protections, to give everyone just kind of an overview of some of the things that you may want to be thinking about when you're working in the real estate space. So in terms of ways that new businesses or new ventures are formed, there's basically a number of different ways. A sole proprietor is basically I go out and I buy a piece of real estate and start renting it. Sorry, I got something popped up there. Okay. There's other ways that you can set up a legal structure to provide liability protection, like a corporation, limited liability company, limited partnership, trust, joint venture. Partnerships can be limited or general, but you do need two people, two partners to have a partnership. A general partnership is basically unlimited liability. So if you and a friend pool your money and buy some real estate, if you're not set up as an LLC or a limited partnership, and you're owning it individually, you could face potential liability if anything happens with that real estate. So it's usually better to set up some form of liability protection with basically an LLC or an LP. Okay, so LLCs and LPs. A limited liability company and limited partnerships are the main ones I'll talk about because those are mostly ones used in real estate. An LLC is basically just a contractual arrangement. A corporation is more of a legal entity. An LLC is set up by state law and is governed by contract. So the the LLC is covered by operating agreement or company agreement. And if you don't have an operating agreement or company agreement, LLC, then you end up with the default provisions of whatever state. So if you form a Texas LLC and you don't have an operating agreement, there are default clauses in the law that talk about how to run the LLC, who controls, manages it, what it can and can't do. But obviously, if you have a written operating agreement, that's a lot better because then you can outline all the specific terms of what you're doing. A limited partnership is very similar. It provides liability protection. It's a legal entity that's formed by filing with the state. And the difference is an LP, a limited partnership needs a general partner and limited partners. An LLC can be just one person. There's a lot more flexibility. You can choose how to tax an LLC versus a limited partnership is taxed as a partnership. All right. So I'm going to send out a copy of the slides so you guys have this. This is just a kind of a table that compares the different types of businesses, whether there's personal liability, you know, and if there's taxation issues, like a corporation is taxed at the corporate level, and then also when a distribution is made, then it's taxed as well individually. So it's double taxation for most corporations, not an S corp, but a regular corporation. All right, so what are some of the common real estate structures? You guys are probably somewhat familiar with these already, but I will go over them a little bit. Syndications, funds, partnerships, and a joint venture. Joint venture is usually more of a contractual arrangement. Sometimes people might use an LLC for it, but it's more of a contract between two different parties that are, for example, in real estate, they're developing a piece of property and they sign a joint venture agreement, each person putting something in and getting something out. I'm going to go through this. I'll show you guys the structures. Here we go. A typical real estate syndication this is an example of an org chart. So at the top in purple, you've got the actual piece of real property that is owned by, in this example, an LLC, which I have listed as the company. That's the syndicate entity or investment entity where investors put their money. Off to the right, you'll see the offering investor members. They become members of the LLC and they put their capital in. And you also usually have a separate LLC that acts as the manager. And then the sponsor or the person putting the deal together owns that management entity. We do that to add a little bit of liability protection because the syndicate entity as an LLC provides liability protection, but if, for example, as a real estate developer, you make a decision on some type of issue related to the property or when to sell, and an investor is not happy and they want to sue the manager that made that decision, instead of them suing you personally, in this structure, they sue the management LLC. So it provides a little extra layer of protection for the real estate sponsor. And the way that cash flow works in a typical real estate syndication, your promote, basically your profits interest and any management fees go down to that management LLC and then flows through to whoever the GPs are basically on the deal. And then the investors get their, whatever the distribution waterfall is, whether there's a preferred return, an 80-20 split, whatever it is, that's what they get based on the terms of what they were offered. Typical partnership, I should have changed that. So a partnership can be through an LLC or can be direct. And in this example, this is through an LLC, but basically each partner comes in, puts something towards the purchase of a property, and gets some kind of distribution out of it. A real estate fund is very similar to a syndication, except you can have multiple properties. So the fund is in the middle. That's the actual company. It can be a limited partnership or an LLC. And then underneath that, you've got usually SPE or separate LLCs that might own either one property or multiple properties. That provides a little liability protection. For example, if there's a slip and fall at property number one, and that person wants to sue, they don't sue the fund, which would affect all of the other properties and assets. They sue the SPE LLC that owns the property. So that's part of the reason for that. Otherwise, most of the structure is pretty similar. You've got either a GP or management entity, which is another LLC. And then your investors are, in this example, they're limited partners, but they would be members of an LLC if it was an LLC. Same thing. Some of the legal issues when it comes to raising capital, you've got the Securities Act, the Exchange Act, two different sections, Investment Advisors Act, Investment Company Act, corporate law, tax law, state law compliance. So there's a lot of different areas that we have to look at when we help people set up to raise capital and do it properly. So here's something that we see quite a bit is, people are confused about this. They say, hey, we've been doing this real estate deals as partnerships for a long time. And, maybe we set up an LLC or we don't. Some people put money in, and then there's, I'm running the deal, I'm the manager or the GP, and I get a split, and then my investors get money out of it. So most of the time when people describe that to me, that is actually a securities offering, which is covered by state and federal securities law. So, we have to worry about compliance there. In terms of setting it up properly, there are different filing requirements, notice requirements to make sure that it's compliant. So most of the time, anytime you have your passive investor, basically you have LPs coming in, that's usually a securities offering and not traditionally a partnership. So we do want to look at securities law in that instance. And the most common test that is referred to is called the Howey test under securities law. The definition of a security is very broad. You think of, okay, a share of stock for Facebook is a security. Okay, I get that. But even a promissory note can be a security. An ownership interest in an LLC can be a security. And the Howey test says even an investment contract where basically you're pooling your money, you're expecting a profit, and it's based on the efforts of somebody else because I'm more passive, then that is a security. So we have to worry about securities law compliance. And that's come up more recently with tokenization and crypto, where the SEC and others have said, okay, crypto is a security in most cases, as well as tokens are usually a security as well, covered by securities law. Okay, so what happens if we don't comply? So let's say we've been doing partnerships and we're just going to keep doing it as a partnership and not comply with securities law. Technically, it's considered an unregistered sale of securities, and both state and federal regulators oversee that. So there is the potential that, the SEC doesn't really go around suing people over $1 million real estate deal unless there's some kind of fraud, but that doesn't mean that we can't. State regulators will. They're more the ones to potentially pursue someone if an investor complains and they find out, oh, well, actually, this was supposed to be a securities offer, they didn't comply. You can also face investor lawsuits. But I tell most of our clients the biggest issue when it comes to making sure you're compliant with securities law is that something called a right of rescission. So a right of rescission means if I'm an investor and I put money into your deal and you didn't comply with securities law, then basically I can sue you for a right of rescission, meaning I get all my money back, plus interest, plus fees, and you have to pay me. So in the real estate context, you've taken their capital and purchased the real property, so you don't have their cash to give back to them. So that can cause a real problem. And also, if you get in that situation, then securities regulators may also prohibit you from raising money in the future. So they can enjoin you from basically going out with capital, and that can have a major impact on your ability to be involved in future deals, not only as a sponsor or a co-GP, or you'd be considered what's called a bad actor under Regulation D, meaning that you may not even be able to be a majority or like a certain percentage owner of a real estate deal. You can't be involved in a private offering. So it has a major impact on you individually. So typically when people think of a securities offering, it's a private placement memorandum that is the most common thing that people talk about. So it's a subject of a lot of confusion, so I'm going to give a little overview. A PPM is a private placement memorandum, and basically it's a disclosure document. It's not a contract. It's basically just a disclosure. So think of a prospectus. So when you invest in a mutual fund, every quarter you might get a prospectus in the mail or by email. And that's basically disclosure of who we are, what we're doing, who manages this, whatever it is, company, and what are some of the results of our operation, what is our business plan, just basics about this to inform the investor and to warn them about potential risks of investing so that they're fully informed. Part of the SEC's mission is to protect investors by making sure they're fully informed before they make an investment decision. So when we prepare a PPM, we want our clients to provide that to the investor before they make an investment decision so that they've had time to review it and to say, okay, I understand what you're doing and the risks involved. I still want to, here's my check for $50K. So that's kind of what a PPM is. There's a lot of security specific disclaimer language. Probably a third of most of our PPMs are just risk factors, where it's basically saying, here are all the risks of investing in this deal. Here are things that could go wrong. These are ways that you could potentially lose all your money. So these are not exactly business points that you can help sell the security, but for what we do is to try to protect you. So when you give someone a PPM or when they review it, they're like, oh my gosh, look at all these risks involved. That's to protect you so that an investor later can't sue and say, hey, I didn't know there was a risk that there's potential bankruptcy or whatever the risk is. The economy could go down, inflation could go up. Whatever the risks are, we disclose those ahead of time. So the investor, this is your protection in court. You get sued by an investor, you're like, here's our PPM. You knew the risks going into this because we fully disclosed it to you. I won't get into too many of the details of when to use a PPM. It's not always required. We highly recommend it. If you have any non-accredited investors, so if you're familiar with Regulation D, 506B, if you have anyone who's not accredited, you are required to give them a PPM prior to making their investment decision. Some state regulators also want to see that you've provided a PPM, even if it's not required under federal law. What are some of the things that go into a PPM? Basically, the Regulation D, Rule 502 talks about both non-financial and financial information to the extent that it's material to understanding of the company, their business, and the securities being offered. So basically, this is almost like an expanded business plan with the risks of investing. All right, so what are some of the key issues when it comes to disclosure, either in your PPM or in your investment deck, anything that you're providing to your investors? Where are some of the key areas that we see as areas where the SEC or state regulators pursue? There's a lot of lawsuits. So here are some of the areas that basically, let me put all these out here. All right, so disclosure and compliance. Anything that could be misleading is a major issue. So if you don't fully disclose everything about the offering, even the bad stuff, that can be misleading. So it's something that you probably should have told your investors, but you didn't want to tell them because you wanted to make sure they signed, wrote you a check. That can be a problem because later they can say, I wouldn't have invested if I would have known, X, Y, Z. Also, when it comes to compliance, avoiding quote unquote security exemptions or registration. The example of this is, hey, we're just going to keep doing this as a partnership. We're going to form an LLC. We're going to bring in basically LPs into this LLC, and I'll get a cut, a 20% split, and some management fees, but we're not going to comply with securities law. Well, that can lead to the right of rescission. It can be basically, the SEC could potentially come after you criminally, but that's pretty rare. And then fees, making sure you fully disclose all of your fees, whether it's a split between co-GPs or you have a property management company that you own that's going to be charging a higher than fair market rate to this property. So you're going to get compensation as a GP outside. So we want to make sure we disclose all of that. We call it related party affiliate transactions or potential conflicts of interest. So your investors are fully aware. And a lot of times we get clients who ask, well, can I do this? Most of the time the answer probably is yes, you can do it, but is it fully disclosed? So are you allowed to charge a certain fee? Most of the time, probably yes, but is it fully disclosed to your investors is the biggest issue that we see. Execution and information. This one is basically not doing what you said you were going to do. So if you tell your investors, and you don't have to stick to every specific detail. If you say, hey, we're going to sell in 5 years, and you sell in the 3rd year or the 7th year, that might not be material. But if you promise people things, and that's a huge issue, never say guarantee, never promise anything that, yes, you will get a certain return, because that's where people get into trouble. They get sued because an investor comes back and they have a pitch deck that said, we guarantee you a 12% IRR, or, all of our prior deals were a 30% return. You will get the same thing by investing here. And that's a problem because you now guaranteed a return, and unless you perform on that, then you have the potential that the investor can sue you saying, hey, you promised me something, but you didn't perform. Misappropriation. This is when you take capital that you raised from investors and you use it for something else, something other than what you told your investors. So this, when you do sources and uses in a PPM, it says, here's the money coming in and here's what we're using it for. Now, the investor funds don't always have to be like, okay, maybe I used $1 million for property renovations, but I told them I would only use 800,000. It's probably not that material. But if you take investor funds and you invest into a separate property, or you loan, we've actually seen this a lot where sponsors, GPs have multiple deals, and oh, well, there's plenty of cash. I just raised a bunch of money over here for this property, but this property of mine over here is struggling and needs a little cash. I'm just going to loan some money over to it. And that's commingling funds and not using them unless you've told your investors that part of their money is going to be used for that other property. That's a problem. So some of the general dues, just a quick summary of that, is keeping your investors informed. Sorry, let's see. Disclose everything, disclose all risk factors. We tell clients to cite their sources. So in the PPM, you might make reference to this market, the current market that we're buying this property in has, here's the current vacancy rate, or whatever the fact is. We usually have them cite the source of where they got that information. Follow the PPM and pitch deck. Be clear about your experience or lack thereof. That can be generally an issue because people try to hype up in their biography that they have a lot of experience or a huge track record. That might not be the case. That's a plaintiff's lawyer is going to look at that and say, oh yeah, they lied to you. They didn't really have that experience. And now that's a basis to sue you. Disclose both best case and worst case. It's always better. I mean, I've been doing this 25 years. The times where people get in trouble, it's not because they told all the negatives. Hey, you know what? I was upfront with my investors, and usually those people that have been in that situation where they have disclosed everything, even the negative, even when things are bad, they've avoided those lawsuits. But if you hide it from people, that's where it becomes a problem. Okay, so this one when I say don't use general solicitation, that's only if you're 506B. I didn't really get into that too much, but Reg D, you have 506B and 506C. 506B is where you go to your pre-existing network. So you have to have a pre-existing substantive relationship with your investor prior to raising money from them. So you can't go outside of that network. You have to have that relationship for that exemption to apply. 506C allows you to generally solicit and even advertise. So if you see on social media private offerings, that's usually a 506C, where you are allowed to generally solicit and advertise. So unless you're doing a 506C and compliant, don't generally solicit or advertise, just stay within your network. Make sure you disclose everything to your investors. Having too many GPs or unlicensed finders. This can be a problem too, where basically someone comes in and says, hey, I've got access to $10 million. I want 10%. So just cut me a check when I bring that $10 million in, cut me a check for 10%, and you're good. So that is technically, you need a license as a broker-dealer of securities to be able to do that. So if someone's not a licensed broker-dealer of securities, they're not allowed to raise capital and charge basically a commission, a percentage. Are a few kind of limited exceptions there where people do co-GPs or other ways that they can try to avoid that, but anything that's transaction-based compensation is what the SEC primarily looks at. So if it's, I raised $1 million and I got 10% at closing in a check, that can be a problem. Now the SEC, just to let you know, is basically looking at a proposed finder's fee rule. There's been a number of committee hearings on this, and there's going to be a proposed rule coming out that will allow people who are not broker-dealers to be able to get a percentage of capital raised. There's going to be limitations and boundaries on what you can and can't do, how much you can get. And again, this is not in place yet. But the good news is that this is something that's been needed for years. And the SEC is finally realizing that and working on a proposed rule that hopefully we can get implemented within the next year. So that would make access to capital even easier, hopefully. Always want to make sure you don't guarantee any returns using funds other than as promised. And I already talked about one of the other issues with finders or a bunch of co-GPs is there's a lot more risk when you add other individuals. So you've got somebody who is a co-GP, they've got access to a group of investors to invest in your deal, but you don't know them that well. You don't know what they're telling their investors. So they might be telling their investors something that is not in your PPM or any of your disclosures. And so now you've got a potential investor that is being told something that might not be true. And then later down the road, that can bite you in the butt because, like, okay, well, this LP lost money. Hey, I was promised a 12% return, and I have the documentation of it from this guy who was a co-GP. So you always have to be very careful and monitor who you're working with, even if you are, co-GPing with multiple people on a real estate deal. All right, here's an example of that I like to show people because sometimes people don't understand what is general solicitation and advertising. So if you go onto a small private network of high net worth individuals that you are a member of, let's say there's 50 people in this small real estate investing group, and everyone's very experienced investors. Posting something just to that private group might not be general solicitation. And this is kind of a gray area that the SEC has talked about. But if it's something that the general public can see, like, for example, if this was a Facebook post talking about a deal, a multifamily deal in Dallas, DM me for more information. That is a general solicitation. If it's anywhere either to the public where the public can see it or to a large group, like let's say there's 10,000 investors in a group, that's probably still a general solicitation that you need to avoid, unless you're doing a 506C. So if you're doing a 506C offering, you are allowed to say things like this, but you have to have accredited investors only, and you have to independently verify that they're accredited, which means you need some kind of documentation from somebody else, not just signing a subscription that says, check the box, yes, I'm accredited. That's okay on other deals, but for 506C to allow you to solicit and advertise, you have to get a CPA verification letter, bank statements, something in writing from another third party that shows that they are accredited. Okay, so this is, I'm just going to list these here, but these are some of the, what I call the 5 R's of PPM review. Whether you're a sponsor putting together a PPM, you're an investor looking at a PPM, I have it broken down into 5 R's. You've got, what are your rights? And so you look at your operating agreement, partnership agreement, shareholders agreement, PPM, all the documentation to find out what are my rights. If I'm being promised something, is it in writing in an actual contract that I'm signing? Subscription agreement, operating agreement. So you want to make sure that anything you're being promised for in terms of rights that you have as an investor are documented in one of those contracts. Returns, what are the projected returns? What are the assumptions behind them? How are they calculated? Risks, what are some of the risks involved with the investment? We want to make sure that we fully disclose any compensation that's being paid to the GPs, if there's an unregistered broker-dealer, like any of these things that are potential risks, we want to disclose. That's why our risk factors on our PPMs are 20 pages long, because we want to disclose all the potential risks to protect our client as much as possible. Reputation, what is the sponsor's prior reputation, prior results? Obviously, past performance is not a guarantee of future performance, but do a little research on the reputation of the people involved. Reasonableness, this is the biggest one that I always tell people as investors, especially. If it sounds too good to be true, don't do it. Whether you're investing in a deal that sounds too good to be true, or you're trying to put together a deal and your returns are just astronomical, they don't make any sense, that's a red flag. Okay, so I wanted to cover just briefly some of the things in terms of exit planning. When it comes to whether it's a real estate deal or a business that you're doing with someone, you want to plan, I call it planning for a business divorce. So it's almost like having a prenup. And a lot of times the terms of this are in your operating agreement, partnership agreement. Sometimes people put together a separate buy-sell agreement, shareholders agreement that outlines the terms of what's going to happen if this business fails or something goes wrong. So examples of that are, okay, well, somebody got divorced, somebody died, one of my partners died, what happens? What happens in the event of someone wants to retire or walk away from the business? Usually we want to walk through all of those potential events and document them in some form of contract so that we've outlined exactly what's going to happen. And that usually needs to be done early on, because people come in later and say, hey, my partner just died, what do I do? Well, you didn't have anything in writing. So now you're going to have to deal with, okay, do I have to go to probate court? What exactly is going to happen? Is this person's spouse now because they had a will that gave their spouse their ownership interest? Now all of a sudden their spouse is now my partner, or their child is my partner. So you can avoid all of these situations with proper planning, but that needs to take place early on. Some of the things that we look at are, what is the fair market value of a buyout? How do we calculate the value? Okay, well, this guy owns 20%. He wants to walk away from the business. How do we calculate the fair market value? Do we get an appraisal? What exactly is the process? So we outline that process, the timeline, the payouts. So if it's all in cash to buy somebody out, or maybe it's partial cash and partially promissory note paid over a number of years, which is common. What are the triggers for a buyout? The most common triggers for a buy-sell are things like death, divorce, You can have things like bankruptcy, disability, retirement, withdrawal. Those are some of the common ones that you'll see. And a lot of times in the case of things like bankruptcy or divorce, we can put terms in, if we do it ahead of time, that have a discounted price to buy somebody out. So you're not, so it provides a little protection in like an example of a divorce where you're not paying the spouse the full price, and those have held up in court. So sometimes we do like to plan for that way, or bad boy provisions where somebody committed fraud and you need to kick them out. You don't have to buy them out at full price. So we can put a discount or some other term in there to cover that type of situation. So part of planning is sort of asset protection planning, if you will. Now, part of that is just setting up an LLC or an LP, which most of you probably already do anyways on your real estate deals. That is asset protection planning for the business because it provides a liability protection so that you as an owner, let's say 3 of us create an LLC and it buys a piece of real property. Something happens at that real property and somebody wants to sue. They sue the property owner, which is the LLC. So if they were to get a judgment, it would be against the LLC and the assets of the LLC, because we don't want them to be able to sue each of the individual owners. So the LLC or LP or whatever it is provides that firewall or block of protection between the asset and the owner. So there's other ways to provide for asset protection planning. My partner Anish talked about some estate planning a couple weeks ago on a webinar here, but he also does this asset protection as well. So there are things that you can combine with both your estate plan and asset protection planning for your business interests, plus all of your other assets, personal assets. So that's something to review as you're looking at your ownership of your business or any of your personal assets. And asset protection and business succession planning are a huge part of both your estate plan and just your business planning in general. You want to plan for what's going to happen in the event of somebody dies, or like I was talking about the buy-sell agreement, somebody commits fraud or a crime and goes to jail. What's going to happen in that situation? Who's in control of the business? These are all things that we can plan for in things like an operating agreement, buy-sell agreements, and also it dovetails into your estate plan too, because if it's owned by a trust, your ownership interest is owned by your family trust. How does that work? These are all things that we need to look at. Okay, so I know I went over quite a bit of different areas. So I wanted to make sure I had enough time to allow people to ask any questions, because I know that there's a lot of different topics that I covered. So I want to open it up for anybody that has questions, and I'm going to turn off my sharing here.
Hey, Chris, if you don't mind, can you share again the last page where you have your contact information? We just wanted to take it so that in case in future we can reach you out.
Yes, let me put that back up.
That's, I think, important thing. Thank you.
And my contact info is on there. I believe we'll probably send the slides out afterwards in PDF. I'll put them in PDF for everyone. That'll have all my contact info. I do have a YouTube channel, Securities Law Media. You can look it up under Securities Law Media or under my name. And I have a lot of free content on there about corporate issues, buying and selling businesses, real estate syndications, funds, the things that people have questions about that they're not sure. I have a lot of educational stuff on there.
Oh, great. Thank you.
Mm-hmm. Any questions?
I have one question, Chris.
Sure.
Yeah, I wanted to know if there are any recent legal or regulatory changes investors should be aware in this year, 2026.
I would say that in terms of the current landscape for sort of the securities law world is the new administration and the new people running the SEC, generally they are looking at things like crypto, digital assets. They're making a lot of new regulations and rules around that. And they're very open to crypto and digital assets. So there are a number of rules that will be coming up that make it easier to do deals. Like tokenization, for example, is one that's a hot topic. And tokenization is basically a form of a security because you're taking, let's say it's an LP interest, and creating a token that represents that LP interest, and then wanting to be able to sell that, or when you tokenize it, it's easier to potentially transfer. Some of the issues that come up in that the SEC is trying to work through is if you have a security which a token represents the LP interest, which is a security, if you go out and let's say you set there, I've seen websites out there that say, hey, transfer your real estate interest on this exchange. They're probably acting as an unlicensed securities exchange. And they could be, taken down basically by a securities regulator. So if someone's doing tokenization, you have to be very careful that you comply with securities law, because you can't just tokenize something and then turn around and put it on a website and start transferring it, because the underlying security has certain restrictions on transfer by law. So we still have to comply with that. Those are some of the main issues, usually relating to digital assets. And then also like I had mentioned, the finder's fee rule, proposed rule, it's not in place yet. So let's see. Those are probably the biggest things that we see are things related to digital assets and crypto.
Mm-hmm. Thank you.
Mm-hmm.
And one more question. I saw one of the slides where you were talking about the exit strategies. And let's say one of the partner is deceased and he doesn't have any will or trust. So how do we go forward in that use case?
So if you're in like an LLC or something, or
Yeah.
Okay. So if you're a member of an LLC, first you look at, okay, is there an operating agreement? Does the operating agreement talk about what happens in terms of a member who dies? Some operating agreements do, some don't. If it's not in the operating agreement, then you look to the default state law where the LLC is formed. Most of the time, those do not cover state law. Defaults do not cover if a member dies, what happens. Usually that's more probate court. So if one of the members of the LLC dies and there's nothing in writing on what happens in that situation, then basically their estate, if they don't have a will or a trust, it's an intestate estate that is covered by state law where they basically reside. So if it's Texas, it goes to a Texas probate court potentially. And then the probate court says, okay, this gets lumped in with all of their assets, this ownership interest as part of the estate. And then there's certain default rules of, okay, do they have a spouse, do they have children, who it might go to. So if it's not in writing, then you can end up with a member or a partner who, like I was saying, that could be somebody's son or spouse or whatever, and you're stuck with them.
Makes sense.
Mm-hmm.
Thank you. Yes.
So when you say of friends, 5 or 6 friends, and setting up an LLC, and a couple of them are passive investors. So is that a case where a PPM would still be the way to go?
So the first part of your question cut out a little bit.
So it's a small group, LLC, right? 6 or 7 people. Maybe you talk to 10 people, and a few of them joined, right? So you ended up with like 6 or 7 people, and some of them are passive, right? And there's 2-3 people running the company, And so in such a scenario is because there are passive investors, right? They're not involved in day-to-day, they're just investors. And so in such a scenario, is a PPM the correct way to go?
So the Howey test says that that's a securities offering, most likely, because you have the passive investors. So you're not required to have a PPM if everyone's accredited. If it's a Reg D, 506 B or C, if everyone's accredited, you're not required to have a PPM. It's a best practice to help protect you, both under federal and state law. So usually it is best to have one. But if it's just a small deal, sometimes obviously the cost involved of a PPM and all of that can be substantial. So if it is a smaller deal and it's all accredited investors, it's not required. So you could potentially do that without it. Sometimes what we do in those cases is if it's a smaller deal and they don't want to have to go through the whole process of a PPM, everyone's accredited, we do a subscription agreement or a purchase agreement for them to buy in with a lot of the disclosures and representations that would be in the full securities offering, and then also attach some of the risks as part of that agreement as an exhibit to say, here's an outline of the deal, sources and uses, what we're doing, and the risks involved as an exhibit to that agreement that they sign. So you've got a little bit of protection there.
Okay, and the PPM is standard fees for it? So the kind of deal, the complexity. Isn't just a document that you put together, PPM?
Yeah, so the PPM is part of a securities offering. So we normally do flat fee securities offering. The average for like a syndication or a fund is about $15,000 total, and that's forming your LLCs, both of them, all the operating agreements or partnership agreement, subscription agreement, the securities filings, and then also the PPM. But again, it depends on the size and the complexity of it. That's kind of an average.
Hey, Chris, just a question on the similar topic, right? So for the PPM, right? So are there any minimum requirements? Like, what investments should go under the PPM and what can be just under the standard operational document?
Again, under Reg D, there's basically, if it's all accredited, it's technically not required to have a PPM, the offering document, offering memorandum that they talk about. So it's kind of something you have to talk through what the risks are with your attorney to see, okay, do we need that? Do we not need that? So there's not really any bright line test other than if you have non-accredited investors, you have to have one, a PPM.
Yeah, but what for an example, right? So if you're just raising the funds not from a public forum, just from your private small internal groups like friends and family, right? Then you're not really going on any of the public platforms or anywhere to raise the funds. So even in that case, you need it.
So if everyone's accredited, it's technically not required. It is a helpful protection for you to have those disclosures, but it's like, as an example, 3 partners come together. 1 is the main person running the deal. 2 are just passive investors, and it's a $500,000 deal or $300,000 deal or something on the smaller side. Paying $15,000 for a full set of securities offering documents probably doesn't make sense in that situation. So again, that's something where we can say, okay, we recommend the PPM, but obviously there's cost issues. So, in that case, we could probably just do the purchase agreement, which is substantially less.
Got it. Okay. I'm sorry. Thanks for this really great information, right? All I'm trying to understand is in what scenarios the standard operational document process does not work, right? So if you're if you're raising money from external sources or anything like that,
Yeah, under Reg D 506B, if it's non-accredited, you have to have one. Other than that, it's kind of up to your discretion.
Okay, got it. Thank you.
Mhm. Other questions?
Do you recommend creating separate entities for each properties versus one holding company? What's your take on it?
Generally, the way, I mean, first of all, if there's a loan, if there's a lender involved, they may not want other assets in the property owning entity. So in that case, you may need to have a separate LLC. If it's not a lender issue, then it's really a matter of, okay, what's the size of this property? What's the size value of the asset? So if it's a, $30 million multifamily asset, you probably want a separate LLC for that, because there's potential issues, liabilities there. If it's, a $400,000 single family home or condo or something, then generally I would say you could probably pool those together, to get to a certain equity value within one holdings LLC. But it's because obviously there's costs involved of setting them up and complying, keeping those LLCs open. So it doesn't really make sense always to have one LLC for every single single family home. You could probably pool something like that together.
Do you think we can combine one residential and commercial, or what do you think?
Generally, looking at what are the potential liabilities is the thing that I look at. Okay, you've got a commercial property, and what's the value? So you can combine residential and commercial into a holding company, but you kind of have to look at, okay, what's the value of each and what are the potential liabilities? Like the commercial property, if it does something that's risky at that property, you probably want to keep any other assets away.
Got it. So it all depends on the liability.
Yeah.
Thank you.
Mhm.
We have 5 more minutes if anybody has any questions.
And I'll share my contact info after with the slides. I think we can probably get those distributed to everyone. If you guys have follow-up questions, you can feel free to email me, set up a time to talk, check out my YouTube channel, all of that. But if there's no other questions, then I guess we can wrap it up.
Yeah. Thank you, Chris, for
Thank
such
you.
an insightful session.
All right. Thanks, everyone.
Thanks, everyone. Have a wonderful evening.